at the end of the 19th and through the early decades of the 20th centuries, we saw a fundamental shift in the climate of ideas. The progressives coming from the elite schools of the Northeast had a fundamentally different conception of government. Whereas the framers saw government as a necessary evil, the progressives saw it as an engine of good, an instrument through which to solve all kinds of social and economic problems. They were social engineers. They were looking at Bismarck's social security scheme in Germany. They were looking at England, where utilitarianism in ethics had replaced natural rights theory. The idea was that law, policy, judgment were to be justified not with reference to whether they protected our rights, but rather with reference to whether they provided the greatest good for the greatest number. That's utilitarianism. Notice how it lends itself peculiarly to law not as adjudication through courts, but rather law as crafted by legislatures. Policy. What shall we do as a people? Shall we have a retirement system through the government? Shall we have health care through the government? And so on and so forth. All of this is much more easily justified only under a utilitarian consequentialist theory of legitimacy rather than a rights-based, what philosophers call deontological theory of legitimacy, which was being eclipsed by utilitarianism. And indeed, that worked hand in glove with homegrown democratic theory. As I said, this was all part of the progressive era, and it took place mostly in the realm of economic regulation, where the progressives sought to regulate all manner of industries and resulted in creating cartels in one industry after another in the name of progress. But it wasn't just in the economic area that the progressives were active. We have a case, for example, in 1927 called Buck v. Bell, which was a challenge to a Virginia statute that authorized the sterilization of people thought to be of insufficient intelligence. A sweetheart suit got that case before the Supreme Court, and Oliver Wendell Holmes, the great progressive from Cambridge, wrote an opinion upholding the Virginia statute that ran no more than 5 paragraphs and ended with the ringing phrase, 3 generations of imbeciles are enough. There followed some 70,000 sterilizations in this country, all part of the modern eugenics movement, which was championed by such luminaries of the day as the president of Planned Parenthood, the president of Stanford University, and their ilk. It was to be, if I may paraphrase the DuPont ad from several years ago, better living through bigger government. And it took place not simply in the economic realm, but in personal realm as well as in this case of Buck v. Bell. They wanted to improve the human race. How are you going to do that if you allow those people to procreate? Things came to a head during the New Deal. That's when one program after another that Roosevelt got passed through Congress was found by the Supreme Court to be unconstitutional during his first term. After the landslide election of 1936, Roosevelt had it with those 9 old men on the court, and he introduced his infamous court packing scheme, his threat to pack the court with 6 new members of his own choosing. There was an uproar in the country over that. Not even Congress would go along with it. Nevertheless, the court got the message. There was the switch in time that saved 9. And it began rewriting the Constitution without benefit of constitutional amendment. It did it in 3 main steps. It eviscerated the doctrine of enumerated powers, the very centerpiece of the Constitution, in a pair of cases in 1937. In 1938, it bifurcated the Bill of Rights and gave us a bifurcated theory of judicial review. And in 1943, it jettisoned the non-delegation doctrine, which gave us the modern executive state that we know and love so well today. Let me take those just a bit more slowly. In 1937, the court, in a pair of cases, as I said, eviscerated the doctrine of enumerated powers. With respect to the so-called General Welfare Clause, which is the first of Congress's power, the power to tax and spend for the general welfare of the United States, the court, in a case called Butler in 1936, revisited a famous debate between Hamilton on one side and Madison, Jefferson, and everybody else on the other side. Hamilton stood for the idea that Congress had an independent power to tax and spend for the general welfare. That couldn't possibly be right, said Madison, Jefferson, and the others, because if that were the case, then any time Congress wanted to do something that was not authorized to it, because no power had been given to it with which to do it, it could say simply that it was taxing and spending for the general welfare and make an end run around the doctrine of enumerated powers. Indeed, they added, what was the point of having enumerated Congress's other powers? Since it could do anything it wanted under this sole power, it could have stopped right there. Well, Madison, Jefferson, and company were absolutely right. Nevertheless, in the Butler decision in 36, the court came down on Hamilton's side, in dicta. That's not the holding of the case, that's peripheral language. A year later, however, in Halvering v. Davis, the Social Security case, the court elevated the dicta to the holding of the case. Thus, the floodgates were open to the modern redistributive state. Congress was now free to tax and spend for the general welfare, not even paying heed to the following words, of the United States. That means they could take from A and give to B as they proceeded to do. The Commerce Clause was the second of the 1937 sources of government expansion. The Commerce Clause was written in order to ensure free commerce among the states in light of what was happening under the Articles of Confederation, where states were erecting tariffs and other protectionist measures for the benefit of local merchants and manufacturers to protect them from competition from out-of-state merchants and manufacturers, a standard public choice economics dynamic. And it was leading to the free flow of goods and services among the states, the breakdown of the free flow of goods and services. So in order to address that problem, the framers gave Congress the power to regulate or make regular commerce among the states. Think of how the word regulation was understood in 18th century cosmology, where gravity regulates the motions of the planets. The idea was to ensure free national trade as against state interference with that. That was the main idea, plus the power to do a few other things that would ensure free trade. Well, in the Jones and Laughlin case, NLRB v. Jones and Laughlin, the court ruled that Congress had a power to regulate anything that affected interstate commerce. Of course, there's nothing that does not at some level affect interstate commerce. And so now the floodgates were open to the modern regulatory and redistributive state. But of course, you could still invoke your rights against these two now vastly expanded powers. And so to address that little problem, in 1938, in a case called Caroline Products, in famous footnote 4, the court distinguished two kinds of rights and two levels of judicial review. If a law implicated fundamental rights like speech, voting, notice the democratization of the Constitution, the court would apply what is called strict scrutiny. The government would have to have a compelling interest. The means it employed would have to be narrowly tailored. In most cases, the statute would be found unconstitutional. By contrast, if a law implicated non-fundamental rights like property, contract, the rights we exercise in ordinary commercial relations, why then the court would apply the so-called rational basis test. If the legislature had some reason, some conceivable reason, that was good enough for passing the statute. And so the court essentially looked the other way, and the floodgates were now finally open. And what poured through was a vast sea of legislation, federal, state, and local. At the federal level, the Congress was unable to handle it all. And so what it did was start writing broad statutes and delegating to the executive branch agencies that it was creating the actual lawmaking power, the power to write regulations and rules under these broad statutes, contrary to the very first sentence of the Constitution, which reads, again, all legislative power herein granted shall be vested in a Congress. All legislative power herein granted shall be vested in a Congress. That's the non-delegation doctrine. Congress was delegating it to the agencies, and the court in the NBC decision of 1943 upheld that delegation. And so we have now the modern executive state, where much, if not all, of the law under which we live is being written. Look what's going on today over at HHS, at the IRS, at Treasury, and elsewhere with respect to Obamacare. That's where all the lawmaking is taking place. Congress issued its broad instructions, and now the rest belongs to the gnomes of HHS and so forth.